8 with me, Miriam Angel, Salim Barisa, and Emmanuel Gona. And in studio is an advocate of the High Court, the one that we have been waiting for, Bennette Nzamba. She is an advocate of the High Court of Kenya, mediator, international mediator, and I am IADR committee convener.
ADR committee.
Good morning.
Good morning.
How are you?
Fine, thank you.
Good to have you here.
Thank you.
Welcome to the show. Now, I want to talk about alternative dispute resolution. And most times we feel like when you have a case, everything has to end up in court. But that's not really the case, is it?
Yeah, no, it's not the case.
Okay.
Yeah.
So what is alternative dispute resolution?
ADR, it is, that's the short form.
Yeah.
It is an out-of-court way of solving disputes. So the Constitution gives power to ADR under Article 159 2C.
Yeah.
Yes. So it empowers that it ensures that we can solve disputes out of court in various ways. There's the traditional systems, and then there's mediation, there's arbitration, and other forms. So ADR has other forms. So in those forms we have, for example, arbitration. Arbitration means this is where there is a third party who is like a judge. But then this person listens to the two disputing parties, can be two or more. But then for arbitration to come in, there has to be an agreement that has an arbitration clause. So that initiates the process of arbitration, because arbitration is also a way of solving disputes, but then the arbitrator is the one who comes up with the final award. It's called an award. It's like a judgment.
Okay. So before you get into arbitration and mediation and all that, can all cases be solved through alternative dispute resolution?
Not really. Not all of them. We have cases like criminal cases, some that deal with sexual offenses, defilement. Those ones are very sensitive. So most of the time it's hard for people to go for mediation under those or settle them out of court. So we don't advocate for that.
So what cases would you advise people to solve through ADR?
Land disputes, when they have like commercial disputes, that is cases, where people have debts and all that. And then any other case, civil cases generally, apart from, the criminal cases that are outlined, especially the sexual offenses.
Okay. What?
So, hapa kwa land.
Yeah.
Land.
Yeah.
You mean land najua is an emotive issue.
Very emotive.
Why na nyingine zinaendaga mpaka zinafikaga hapo kwa nimesema criminal.
Yes.
Na watu wanabeba land na uzito. For example, along the coastline hapa, issues za land unajua squatters jina na nini na bla bla bla.
Yes.
Why haijapewa sitaki kusema haijapewa uzito. Sitaki kusema haijapewa.
Hiyo ni neno mbaya sana.
Sitaki kusema haijapewa uzito, nitakuwa nimeenda overboard. But ukiconsider hapa pwani na story za land, ni sawa kwamba watu waende wakae wazungumze wapate mwafaka?
Yeah, ni sawa kabisa. Actually kusuluhisha haya mambo ya shamba kupitia njia ya mediation, kwa sababu unaona in as much as land is very dear to the heart, watu kama mimi hufanya kesi mingi sana za land na watu wanaelewana. So ukikuwa na kesi kama hizi, kwa sababu utapata shamba watu wanapigania kitu kidogo, maybe ni mpaka ama umeingia ndani ya shamba yangu. Wengine kama ni familia inakuanga mambo ya kudivide. So mkishaelewana tunaweza tukadivide, alafu wafanye subdivision, who will bear the cost, wana agree, because kama sema in mediation, before we get to the details, it is the parties themselves are the ones who come up with the final agreement, the final mediation settlement agreement. So which in a form of in a come up na kama that is now will be considered as the judgment of the court. So it is important to, it is a good way to, I'll give maybe the benefits baadaye kufanya hizi vitu. It is a good way of settling disputes, lakini saa zingine kusema kweli huwa zinashindikana, watu wanashindwa kuelewana. So tusiseme ati haijakuwa na uzito, ni kitu nzito, lakini ikisolviwa huko nje zaidi inawapatia parties wenyewe fursa ya kuweza kuelewana zaidi.
So now let's now look at processes involved in alternative dispute resolution. So break down mediation and what does it mean?
Mediation is it is a way of solving dispute where a third party is involved to facilitate the process of let me say of settling this matter before the third party. So we have a neutral third party who hears two or more disputing parties, and then he will facilitate the process. He or she will not take part, like as in he will not guide the parties in how they are supposed to go. It's just a facilitation, like an idea. You talk to this one, you talk to this one, so he's like the in between. Then
and this person is neutral,
very neutral. If in case, because we have rules that govern mediation, so if you find that maybe we are friends and you feel like it will bring bias in settling the dispute between the two of you and Gona, then you can recuse yourself as a mediator from ongoing with that matter, or even as an arbitrator also. So biasness is one of the things that makes a mediator or an arbitrator or any person that does ABR then step down from doing it if they feel they will be conflicted.
So if I have dispute with Gona and so this process is so when I have dispute with Gona and I want this resolved, most times the first thing that we're thinking about is I need to get an advocate, right?
Yes.
Okay, so I go to the advocate, or I get the lawyer and I say, hey, Bennette, this is my issue. And then so now later on you're going to advise me that instead of us taking the matter to court, we should consider mediation. So meaning an advocate is involved. So this mediator, are they also an advocate?
No, not necessarily. You really don't have to be an advocate for you to be a mediator, because we have different people who are in different professions who are mediators. Even arbitrators, we have different people who have just done the course, because it is it's all about, let me say, we can call it's also a skill. It's a negotiation, settlement skill. Like we always mediate, even in our houses, when your children fight or when your parents are fighting, it's when you resolve the dispute or between you and your brothers and sisters, that's a way of mediation. So it's just a skill, and it needs you to be a good listener, for example, and so it's anybody can be a mediator. We also have, maybe if I may, we also have private mediations. So sometimes when it is court annexed, when it has emanated from the courts, then that becomes a court annexed mediation. So that's in the court annexed mediation, we have a list of accredited mediators by the judiciary. So there's a list in the website, in the judiciary website, where you'll have all these mediators. Then if it is private, then any mediator who is also not in the list of accredited mediators under the judiciary system can mediate outside. So the parties themselves, as you've said, parties will go to an advocate, and then the advocates may say, let's mediate, or it might be initiated by the courts. When the advocate files the matter, because there's a process, maybe if you ask me, I'll explain the process. When the advocate files a matter in court, then the courts will screen. There's something called screening of the mediation, of all the files. So the registry that deals with mediation, screens all the matters, and then but it is a bit also hectic. So it is step by step. Like now I know they're dealing with the land cases, the ELC court, the environment and land courts matters. They're screening all the matters so that they refer all of them for mediation where necessary. So the matters will be screened to see if this matter is fit for mediation. Does it reach the standards that then this matter can go for mediation? And then when it is qualified, when it has qualified for mediation, then the registrar, the DR, brings out the matter and appoints a mediator from the cadastre. The cadastre now is the list of all accredited mediators in the judiciary system. So he will appoint a mediator from the cadastre, and then now the parties are going to be informed that this matter has been set for mediation. This is your mediation through notification. It's a whole process. And then they will be appointed, and then they go with their advocates if they are represented. If they are not represented also, they can go, the mediator will arrange, will communicate to them, then they will attend by themselves.
Okay.
Yeah.
Is there a way kwamba huyu mediator anaweza patikana before hiyo mata ifike huko kwa court? Like me na Salim tumenunua pengine plot na kwa bahati mbaya tumeuziwa plot moja. Sasa kuna venye ambavyo tunaweza pata mediator before kwa court, ama ni tupatane kule alafu ndio ikuwe referred huko, na kama pengine inawezekana kwa mfano ni nani anatafuta, because sote ni kama tumekosana.
So unaona in mediation, kwa sababu hakuna clause kama hiyo ya arbitration, hakuna yani mahali mmeandikiana kwa agreement that in case of a dispute kama sasa hii kesi yenye umesema, then we will result to mediation. So nyote wawili wenye hamsikizani, mkielewana hii kesi badala ya kupeleka kotini si tuweze kusuluhisha nje ya koti, then mnaweza mkaenda, kuko na different organizations zenye ziko na mediator. One, unaweza ukaenda kwa judiciary tu useme you need a mediator, ama pia wewe mwenyewe ukigoogle pale kwa judiciary website uangalie mediation, utapata list of mediators wenye wako accredited. Then unaweza ukachukua mmoja hapo na contact ziko hapo pia, upige umwambie naomba kwa mediator wetu nini msoto. Si lazima ati uende kotini. Ama kuna organizations kama Chartered Institute of Arbitrators iko na pia mediators hapo, ukiwafuata wanaweza wakakupatia. Kuna Suluhu, kuna MTI ni Mediation Training Institute. Kuko na different organizations zenye zinaweza zikakusaidia na mediator. Yeah.
So for this mediation process to happen, if Salim and I have a dispute, we both have to agree to go for mediation, right? Because then I can't force him into...
Yeah.
So now, because I mean we're already in conflict, so I have to talk to him and say let's go for mediation.
If there was a counsel, then it would have been easier, know.
Okay.
But if there is no counsel, sometimes it is very difficult to to get at that decision as individuals, and we are disputing. So it is a hard task, but if parties then just can talk and decide, it will be better, because you look at the cost implication. Of course, I'm an advocate. I do my matters. I wouldn't want all the matters to go.
Yes.
So yes, we would want to solve matters faster, because the thing is also, as advocates, we always think that mediation has come to to remove our bread and butter, to take away our bread and butter, but that is not the case. I'm also it was a process as we are learning that, and we're trying to make sure that this goes out there, that it doesn't take away the bread and butter of advocates, because it reduces backlog. It actually takes away judicial officers' work. It reduces backlog for the judiciary, and it is better when you solve cases out of court. And as advocates, of course, you need to charge your instruction fees. You see, you charge your fees before you continue, and since it is like a court process, because even when you do it as a private mediation, you need to register that decision, the settlement agreement, in court for it to be binding. Because if you don't register it, then you've done it out here and you've not registered it in court, then it doesn't make any sense. Tomorrow you can go and file another suit, then you say we agreed, but where is the decision? Is it binding? There's no authority that has so you'll register all those things in court as a private mediator for that decision to be binding.
Okay.
So I'll take you back pale mali umesema pa screening. There are so many matters ziko hapo, and then you do the screening. What determines that hii ni kesi ya kwenda mediation ama umesema arbitration sijui kama hiyo? What determines ni vitu gani ambavyo kwamba vinaangaliwa kwamba hii inafaa iende kwa mediation, hii haifai haijafikia hapo? Ni vitu gani vinadetermine on the side of the court kama hiyo huko nje?
Yes, sasa on the side of the court doesn't court haifanyi arbitration nimesema arbitration ni separate. It has to emanate from an agreement, a clause, arbitration clause. Lakini sasa ikikuja kwa mediation hiyo ya court, screening inamaanisha watachukua kesi, then kuko na vitu ambazo wataangalia kama kule kwa registry. Hiyo ni kazi ya sasa judiciary under the mediation registry. Wataangalia maybe hii dispute kesi labda imekaa kotini muda mgani, hii dispute ni aina gani, what nature is it, zile matters zenye zinaweza zikakuwa mediated ama is it zile matters zenye ziko out from mediation zenye tumesema kama sexual offenses, gender bias, hizo abuse, you can't mediate such matters. Divorce, divorce sometimes tuna mediate hizo matters. So unaangalia does it fall under those categories? Then hizo vitu those are the main things that they look at. Imekaa kiasi gani kotini kwa muda mgani, then parties hizi unaangalia facts of the case, hizi vitu zenye ziko hapa watu wameleta kotini, do they look so it is like there's a guideline under the mediation rules that shows how you screen those matters. Those are a few that I have mentioned.
Okay. So we've talked about one method, which is mediation. So under I think when we look at alternative dispute resolution, you also say that there is arbitration.
Yes.
What does that entail?
Okay.
Yeah. As you break down other methods around alternative dispute resolution.
All right, thank you. So in arbitration, it means there's a third party who is also neutral. Then this third party will be an arbitrator. That means you're like a judge in this situation.
Okay.
So parties will then, for it to be taken up, it is a bit costly also than mediation, but for it to be taken up, then there has to be an arbitration clause somewhere between the disputing parties. So like for example, if it's a company, most of the time it's companies that go through that in their agreement, or they will say there is an arbitration clause. You see, like when you're doing contracts, there has to be an arbitration clause that says in case of any dispute, we will get an arbitrator from this institution. It has to specify from this institution. Then all the parties, like you can choose your arbitrator and you can also choose your arbitrator. So it will be stated specifically there. It is a huge clause. It has all the details. You have to state then the venue and the law that will be used. If it is in Kenya, then it will be the court that sits in Kenya. The arbitration will use the laws that sits in Kenya.
So this, when you say it's disputes between companies, it's just an organization disputing with another organization?
Sometimes, or even, you see, like for example, when you take a tender, let me use a tender, and then in the agreement, in the tender documents, there is, in case of a dispute, they have put an arbitration clause.
Okay.
Yes, or even insurance. You know, we don't read our insurance policies.
We don't.
So you will notice there is an arbitration clause. So, for example, if you have taken your car insurance, and then you've not read the policy, so gari yako imegongwa and stuff, you need comprehensive and all that, you have paid even excess, then there is an arbitration clause there, and you did not go, you did not start from the arbitration clause. So the advocate, you filed the matter in court directly, so the advocate on the other side can raise something called a preliminary objection, that is a PO, saying that, you did not follow the correct procedure. You've come directly to court, and this policy says you need to go first for arbitration before going to court. So
Okay.
that bars you from continuing with the court matter until you go back for arbitration. So arbitration then, as I wind up, the procedure is that parties are allowed to bring all the evidence, bring witnesses, even in mediation, bring witnesses, bring evidence. Then the arbitrator will hear you. It's like a court process, but now outside. Then you pay. Each party pays. They have a remuneration, like the advocate's remuneration, where you pay the arbitrator, and it is per hourly. You pay per hour. Then it depends with the institution where you are getting the arbitrator from. Most of the time, in most contracts, they will write the Chartered Institute of Arbitrators. They will get an arbitrator appointed from there. And then there's the Nairobi Institution of Arbitrators. They will get an arbitrator from there. So you have to specify which organization will give you an arbitrator. And then you pay them according to their remuneration order of that institution. So it can be, sometimes you can see, if you're, then it depends on the category of the arbitrator they will give you, because there are different categories. So if you're given an associate arbitrator, the charges will be less, at least maybe let's say 5 to 10K per hour. Each party pays 10K per hour. Then if it is a member, you can pay up to 50,000, 80 per hour. So it's a bit costly for a normal mwananchi for arbitration.
So that's why you're saying arbitration, it's more of organizations or rather
Yes,
companies.
most of the time, yeah.
Okay. How fast, both for mediation and arbitration, if people say that, okay, fine, we're not going through the court, how fast would cases solve?
In mediation, we always have a timeline of 60 days.
Okay.
Yes, but with leave to extend. If you see parties are still willing to negotiate and all that, you could still extend.
Yeah.
Then with arbitration, there's no specific timeline, because it depends with, it's like a court process. It depends with how long the case will take. Because you need to ensure that all parties feel like they have had justice. They have been heard to, their fulfillment. Even, yes, in mediation it's the same.
Yeah.
But then we have a timeline under the courts, under the judiciary system of mediation. There's a timeline, 60 days. After that, if it is too long, you need to extend the time. If parties have not resolved and you see there is need for you as a mediator to continue hearing them.
Okay.
So for arbitration, I have said there's no timeline, because it's like a court process and it can take time. I'm not sure if there is timeline, unless it depends on the institution themselves, if they have capped some timeline. Then what did I want to say? Timelines. Then you file now for arbitration, if you get an award. It's not a settlement, it's different. The name is different. The judgment is called an award. This award is given by the arbitrator. The arbitrator, he will sum up whatever you have said, because it's like a court process. The advocates need to write submissions and all that, put case law, then give the arbitrator now to write the final award. So it's called an award. This award, if parties are not content with it, they then appeal in the High Court. So you have a right to appeal now. From arbitration, you can go directly to High Court and appeal.
Okay.
Yeah. In mediation, if you have not settled the dispute, you go back to the court where the matter had been filed initially. You go back to the court. So if it was filed in the magistrate courts, you go back to that court. It's referred back to court, and you start from there. Yeah.
And what if now it was not initiated from the court? Ni huko nje?
Yes, if it was not initiated from court, then it means you are at liberty now to go and file your suit afresh.
Yeah.
But then you will indicate, so that you are not pushed for mediation again, you will indicate that we had tried
mediation and
it didn't work.
Okay.
Yes. Then, you had asked other methods of solving disputes. There is negotiation. Negotiation is where now the two parties or more will sit down and help each other, you try and solve this matter together. Most of the time, sometimes there might be a third party, but most of the time there's no third party. Sometimes there might be a third party. So the purpose of this third party helping with the negotiation, then this third party, like when we were fighting in 2017,
207.
yes, 207, we had Kofi Annan coming.
Yeah.
So that was like negotiation. He came and, you know, tried and solved. There's a third party, very neutral. He will help you try and settle this dispute together. So there's a slight difference in all the processes. Then there's conciliation. Conciliation is also, you know, more so the same thing, like negotiation. Yeah. What else? There is under the constitution, we have AJS. AJS is now the upcoming traditional systems. Traditional systems now, that is alternative justice system. The judiciary has now taken it up. It's trying to ensure that it is out there. So this is, you know, when you go to the chiefs, the local authorities to settle matters out there, that is, it will still be recognized as you're settling matters out of court. So the judiciary is trying to advocate for that. Even when people settle matters, ndo siku hizi utasikia polisi wanasema mnaweza mkaongea, even police can settle matters out of court. Yes, when matters are reported.
I think when you're talking about now the traditional dispute resolution, it's more of a question of what cases should be solved under traditional dispute resolution. And I'm glad that you put a disclaimer on the sexual offenses that should not go there. Right? And most of them are those, you know, and you find that such cases, you find that to resolve, you know, kifamilia, kinyumbani. Yeah, you hear that. And those are not supposed to be solved that way. So what should be under the traditional dispute resolution? What cases, what should people solve? You see, let me take you back in, you know, our grandfathers' ages. That time, we used to have people would have these cases, like, for example, here in the Maasai community, when you commit murder at that time, then you'd have to pay a certain number of cows. I think it was 20 or something, and then they will cleanse you. So those are the traditional types we are talking about. So under the traditional system, it's not capped. So that is why it's still a new area that even the judiciary is trying to, you know, get authority to get a law that will guide it and all that. So people can solve anything because it's not guided per se. Yes. So you can say, like, for example, yes, and when I still take you under the traditional system, when people are solving, that is why we'll have like the clan members. For example, you are found that you are a witchcraft, so you are a witch, a witch. Yes, a witch. So you would then be cast out of the community or something. And we had those ways that they used to settle matters. And since I'm a Kamba, under the Kamba, they used to take something called a kizito. You know, if you have done something, then you will take that. It's like an oath. So if you take that oath and you have done it, then you will die. So I hear. Yes. So every tradition, every tribe had its own way of settling dispute, and they would settle. Even, you know, cases that now in this generation, and because we are guided under laws, would not be settled out of court. So under the traditional, I think it is because most of the time these are state organizations that would do them, you know, like the chief, the DPP would do when it is a defilement case, maybe that is related to young people who are under 18, you know, that is juvenile prisons. If they are found guilty and all that, they would listen to the merits, the facts of the case, and then decide, do we do a deferment? You know, we then let this child serve under pro bono because he's still growing, and maybe he had defiled another young girl and they're pregnant. So there are those circumstances. So under the traditional, I would say, because it is still not regulated, you'd find such cases would still be solved kwa chief, though it is not appropriate. You know, such cases are
criminal cases are very individual and they should go through the court process.
Yeah. So how do we regulate? Because I know we're trying to clear that backlog.
Yeah.
You know, there are a lot of cases that are pending. Yeah. So how do we regulate the traditional dispute resolution method? Is there a way?
At the moment, as I have said, we don't have any. The best way that would be, then we have policies around it, but the best way that would be is when we have legislation that then gives guidelines on what things should be, you know, and what should not be. But the policies have outlined, you know, such like same as mediation, sexual offenses, under the policies, this should not go for AJS. Yeah. But then there is still no law that governs it, you know, for conclusively. So it is maybe it should be someone's, you know, you think about it as a person, and when you have brought this such matters, let's say if you're a chief, you just know that this should not be my jurisdiction.
Yeah.
So let me just let these people go file these matters, you know, in the correct procedure. Yeah. Are
a lot of people opting for alternative dispute resolution?
Not quite. It is about, we can say about 30% of coverage or 40. But since there is still a lot of awareness that needs to be done, because when you talk to normal wananchi out here, they feel the best way on how I can solve a dispute between you and me is I should just go to court. Twende kotini. Utasikia watu watasema hivyo, nitakupeleka kotini. You see? So people think court is the only best way to solve disputes. So it is not really, it has not hit the ground, but that's why there is a lot of awareness. And now, you know, everywhere everything is just turning to mediation because it's a cheaper process, and then it is fast. It is capped under time limits, for example. Then those are the main things. And then it is also not, it doesn't have a lot of, you know, legal jargons and all that. It is very smooth for anyone. That's why anybody can practice that. You don't have to know the law for you to be a mediator or for you to mediate. It's just straightforward, easy for anyone wananchi.
Sasa hizi kesi za magogoni mwanzo za mashamba wazee wa mtaa pamoja na chief. Unajua zingine inaenda mpaka haya mmeelewana halafu mnaondoka hivyo bila makaratasi yoyote. Sasa inafaa pengine mkielewana vile ndio mmeenda pale wamesaidia mpaka mmeelewana. Na hakuna any documentation. You need maybe muende sasa kwingine sasa mkaandikiwe kwamba mmeelewana kule, ama sasa mnafanyaje? Because mostly ni ile mmeelewana sawa. Sasa hakuna chochote ambacho ile tu mmeelewana na mdomo.
Sasa unaona ikikuwa hapo kwa kuelewana, anytime unaambiwa the general rule of the thumb, always put everything in writing. Unaona, mkishaelewana lazima ikuwe imeandikwa chini, kila mtu wa sign, witnesses wake wa sign. Ndio kama tuseme kitu kingine ikifanyika, hata kama labda chief hajui kwamba anaweza kaenda kufile hiyo kotini kama private mediation for example, ama party yoyote anaweza kwenda kufile hiyo kotini kama private mediation, then inafaa kila mtu aweke witnesses wake ikuwe. So in case of any dispute, sema hiyo agreement venye mmeandika pale haijaenda, mtu mmoja akose kufanya vifungu vyake, then unaweza ukaenda sasa kwa wakili. Uende useme tu na tuliagree hivi na huyu amekosa kufanya hivi na hivi. Sasa hii nataka kupeleka kotini. Kuna evidence tayari. So uko nje lazima, kwa sababu kila kitu kotini lazima ukuwe na evidence. So hata yeye ukifanya anything, mtu yote anything, make sure you put everything in writing. Hata mtu akikupigia simu mmeongea nini, follow by email. You know, we discussed this if it is something that is sensitive. Kila kitu. Hata heri uandike simu kwa WhatsApp. Unaona shida mingi mali utapata kesi nyingi zina flop kule nje, kwa sababu umeenda mkafanya kesi ya shamba for example, ukanunua shamba na cash. sasa hauna evidence, ule mtu atasema mi shamba ni yangu na alikuzia, lakini bado atasema shamba ni yake kwa sababu labda yako na makaratasi na wewe ulilipa cash na labda hujamaliza kulipa, achukue auzie mtu mwingine. Hivyo huwa zinafanyika sana. So haukuwa na evidence, ndio naambiwa because you need evidence every day. Usiwahi lipa kitu na cash.
Yes.
Fanya na M-Pesa, itakuwa na evidence kwamba ulipatia na pesa, nilikupatia wewe go and pesa. Hivyo. Ama ufanye na nini inaitwaje, check ama whatever means. Kama watu wana check, M-Pesa is just good. Usipeane pesa cash because hautakuwa kuna evidence ya kuonesha nilikupatia pesa.
Na nikipiga picha mtindo wa kile.
Ukipiga zile cash pesa picha.
Mna handshake, unapeana bahasha alafu pigwe picha. Ndio hii.
Na ni itakuwa labda utaweza kuprove ni evidence, lakini hiyo bahasha ni iko na nini? Unaona kama sasa ni bahasha, mtu atasema inaweza kawa bahasha iko na barua.
Ni pesa, ni pesa.
Umeshikilia pesa.
Hizi.
Inaweza kawa ni pesa za harambe. Yaani itakuwa kwa a lot of things to prove.
Wakili is wakili.
You need evidence.
Yeah, you need a lot of you need
Pesa za zikawa ni za harambe. Si za shamba.
Ama unaweza kuwa unampatia tu token ama mmedecide umpose na some cash money, you know.
So we can make assumptions.
Yeah, you can't. So it is good kukuwe na evidence. Then always make sure the agreements, always have witnesses when you are doing hizo agreements za huku mtaani. Ndio sasa hata mkifanya agreement kwa police wa stamp pale, hiyo agreement iko sawa, verified, then you can file it in court, useme tulielewana hivi, huyu mtu nilimgonga na yeye alinigonga, tukaenda tukaandikiana, ndio hii na ime-certify. So hawezi kaleta tena kesi tena, you know, kotini na tulielewana nikamlipa hivi kiasi. So anakuwa stopped kama kuko na evidence.
Na hawa mashahidi na ushahidi. For example, so kama hiyo story ya Magogo ni Agoni. Mashahidi wanaohitajika pale ni mmoja, ni wawili, ama
ikikuja kwa mashahidi, the best way kwanza, yani ile kitu mzuri usikuwe na shahidi mwenye ni familia member, kwa sababu utasemekana bibi yako hata ukimleta kotini kesho akutetea, atasema tu atakutetea kila kitu, itakuwa you know on your side. So bring someone who is, you know, a friend, someone who is known to you. Mtu unaweza kawa mtu mmoja ama wawili. Sana sana kwa land cases huwa tukiandika zile agreements zetu kama wakili, we say at least two witnesses. It is better to have two witnesses, unaona. Ndio sorry in case of anything, kama huu mmoja hayuko, huu mwingine atakuwa. Unaona.
Okay. Now let's look at, because you say you're going to do it late. I know you've mentioned it in part, the benefits of alternative dispute resolution.
Okay. First of all, it is cost efficient.
Do I pay when I'm going for mediation?
If it is court annexed, you don't pay anything. The court facilitates the mediator. The court pays the mediator per file. If it is a private mediation, then you have to pay the mediator, because atafanya kazi ya bure kweli. You get, so the mediators will set their own terms of payment, because now we don't have a regulation that guides mediation on how to charge clients. But now, of course, they will be fair, because since it is an out of court settlement, it depends, so they will be reasonable. So it depends from a mediator to mediator. And then so that is for private, you'll pay. And then the other thing is that it is fast, because it takes a short time for disputes to be resolved. Then the other thing is what? I am trying to think through them. Yes, it is easy for anyone to go through them, you know. It's not it doesn't have, you know, legalese, legal jargons and all that. So it is a process that is very familiar. It is familiar to everyone.
Okay.
Yeah.
All right. Are there, I mean, with the cases, again, when we think about matters law, when there's a case, we always feel like it's expensive to hire an advocate, right? Or because there's always a fee. Are there instances where one can get pro bono services?
Yes, there are.
Yeah.
Actually, I think maybe it's not out there. But when you have a civil dispute includes any land matters, anything that deals with commercial. You can file for a pauper brief. So a pauper brief is where you as a citizen, you cannot afford to pay an advocate. So there is a list of advocates that is kept with the judiciary. I mean the courts where that station you would want to file. So the pauper brief is for civil matters. So someone will go and say, I can't. You'll write a letter through the executive officer, and then you say that you're requesting for an advocate because you cannot. Then the court will appoint an advocate for you and give you. That is for a pauper brief. And then if it is for criminal cases, then you also can write if for pro bono matters. But most of the time you'll find, yes, you can write for pro bono matters and get an advocate through the same process to the executive or chief officer in the court under the criminal court. But most of the time you'll find that the court itself gives advocates to people, let's say for example, who have committed murder and are in custody. They cannot afford an advocate. Or even when you've committed murder and you're yet to be charged, when you're charged, when you go through the process, then the court appoints an advocate for you to do it for free, so you don't have to pay that advocate anything. And then some of the times you'll see they'll give an advocate to conduct like the Tononeka, the children courts. So advocates will be appointed to help these young persons who have committed offenses. They'll be given an advocate.
Okay.
And then yes, that's essentially it.
All right. Yeah. We have been speaking to Bennette Nzamba. She's an advocate of the High Court of Kenya. Before I let you go, what if for somebody who's listening and they want to reach out, what are your specialty? Is it specialty?
Oh, yeah. Okay, so I deal generally with criminal law. I deal with mediation. I deal with immigration law. You know, when you need permits and you're a non-citizen, you want to become a citizen. Then insurance claims. Yes, and conveyancing also. So it's a wide range. Yeah.
All right then.
Our offices are at TSS Towers, 5th floor. If you would want to visit, we are there as Bennette Nzamba and Company Advocates.
Thank you so much for making time. Yes, we've been looking at alternative dispute resolution. Do not shy away from going the mediation route. The traditional way. Yeah?
And the mediation route.
And the mediation route. I think I would opt for mediation and then negotiation.
60 days.
60 days.